Welcome back to another episode of the Cannabis Community Insider. Today, Penelope and I are joined by another very special guest, Joseph DeMatteo, who brings a wealth of expert knowledge in the social and criminal justice field as it relates to New York. As many of you know, New York has legalized. A lot of things are happening, and they are moving very fast in terms of the licenses and what's happening on the business end. But for us and our community members, we're also interested in the social justice side of the conversation and how that affects the people in our community. And so with further ado, I'd like to invite Joseph to introduce himself, say hello to our audience, and welcome to the show, Joseph.
Thank you, Abraham. Thank you for what you do for everybody. Thank you, especially Penelope, for all the incredible hard work and perseverance that you show in the cannabis area. You guys have a lot to be proud of, in New York State especially. Anyway, my background is as follows. I'm a lawyer. I spent the first 11 years of my career prosecuting people in Manhattan. I am embarrassed to say that I followed and towed the line for my years as a prosecutor, and I prosecuted marijuana cases, people who were selling nickel bags of marijuana in Washington Square Park, and that is now hopefully going to be corrected. I spent 11 years doing that, and then I went out and began my own private criminal defense practice, eventually forming Bernfeld, DeMatteo and Bernfeld, which is now located here in Tarrytown, New York. We were in Manhattan for years. And I did a whole garden variety criminal defense practice, but recently I totally shifted that. And all I'm really focused on now is trying to help people who have prior convictions overcome the difficulties that come with that. I do that for a living, so I charge money to do it, but I also do that in appropriate cases pro bono. I'm very excited about what the marijuana law, the MRTA, which I'd rather call the cannabis law, but it is the MRTA. I'm very excited about what this means for New York State, both as far as legalizing cannabis is concerned and making it available to all the people who need it medically and recreationally. But I'm even more excited about what this means for all those folks who were adversely affected because of the war on cannabis in their underprivileged and distressed communities. Those are the communities that were hit hardest. So the new statute has a whole bunch of things that it's going to do, both in terms of using the money from cannabis sales to help those communities. And what we're going to be talking about today is using the mechanism of the court to tell all of those people who were convicted under our misguided cannabis laws that the government cares and that the government, without you having to lift a finger, is going to wipe away your marijuana conviction. It sounds easy. Nothing that the government does is easy. There's some complex laws involved, and hopefully we can talk about that and get a better understanding of how that's going to operate today.
That's a fantastic synopsis. I appreciate you providing some of the context of where you started, what you worked in, how you switched sides to help the other side restore the damage from the wars on drugs, and now the efforts that you're working on today in New York. For our audience, when you typically get arrested and convicted, you talked about the process of trying to help people with expungements. Can you tell us a little bit more about that? What is an expungement? How do you get to that point? What qualifies? What doesn't?
Yeah, well, expungement is something very new to New York. It's not something that we've generally had. In some states, if you get arrested and convicted and acquitted of an offense, everything is expunged, meaning the records are completely destroyed. They're thrown out, they're marked as something that you can't look at. New York State has never really had that. Even a dismissed case, there's always been a mechanism that you can go in and look at those records. What's happening here with marijuana, old marijuana convictions under the MRTA, is that a mechanism has been provided to get those prior matters dismissed, which we're all familiar with, sealed, which means closing off the file to the rest of the world, and then expunged, meaning that the documents in that file are going to be marked as expunged. What the benefit of that is, I'm not 100% sure on, but it's going to be marked as expunged so that if anybody sees that record, it's going to say it's expunged. And there's a definition of what that means legally in the law. Beyond expungement, if an individual wishes, they can request to have their record destroyed, meaning that the police department, the court system, the fingerprints, the photographs, everything actually is burnt. I mean, kind of like cremated and gone forever. And there's some pros and cons to that, which if anyone's interested, we could certainly get into.
Yeah, you've piqued my interest. What's the pros and cons of having something expunged or not?
Yeah, well, let's say back in 1979 or 1976, I was convicted of a serious felony under the controlled substance law, but really it was only marijuana. I've lived my whole life harboring under that felony conviction for what now would be maybe even a violation. But back in the 70s, marijuana was still defined as a controlled substance. So under this law, the Office of Court Administration, the New York State Department of Criminal Justice Services is supposed to figure out a way to identify my case and dismiss, seal, and expunge it and notify me. And then I have a decision to make. Do I wish to have that record completely destroyed, or do I want to leave it there just in case? Just in case of what, you might ask? Okay, just in case the Department of Homeland Security decides that they want to deport me because I have an old controlled substance conviction. They might think it was cocaine or heroin or something more serious than cannabis. But I'd like to show them, hey, this was just cannabis. This was, as a matter of fact, this was an ounce of marijuana that I was convicted of selling or possessing, and I wound up being convicted of a felony because that was what the law was back then. It's not what it is now. So by showing that agency something, I might be able to stop them from doing something. Another example would be, background check companies have purchased data. Years and years and years and years, they keep purchasing these criminal records or obtaining access to them somehow. And now let's say, something gets released that wasn't supposed to be released to an employer, a potential employer. And now I'm talking to that potential employer and they say, hey, by the way, you didn't tell me about your prior felony conviction. And I mean, oh, well, I thought that was expunged. Oh, well, it hasn't been. What was that? Now, there's problems with that conversation already under our law, but bottom line is I want that job. So I can say to the person, well, look, I can prove to you what those charges were. It was just marijuana and a small quantity of it that. And then you could go to the court system and you could obtain those documents and you could show this potential employer that it was really something of no moment, and hopefully you get the job. So that's the decision you would have to make. I'm trying to think of why somebody would absolutely want them destroyed. And I can't really come up with a reason for that other than just someone who's deeply, deeply concerned about their privacy and is very cynical about the government, releasing information, which might be a legitimate concern, obviously.
And now, is it possible, for example, if somebody's already gone through the process of dismissing, sealing, and expunging the records, can they request a copy of those expunged records for their personal obtainment and then request to have the remaining records destroyed?
Exactly, yes. So that would be the advice that I might give somebody. Oh, if you're going to do that, the only thing with that is you're then bringing it back to yourself. And your own credibility becomes part of presenting that record. Is that a complete record? Is it an incomplete record? Did I fudge it? Did I tamper with it? People are distrustful. So it's nice to know that, oh, this is the record that the court it's maintained. Maybe, you know.
Wow.
Good to know. Always interesting to see why some things are the way that they are. Right? You never really think about the reasons that it might affect people, but having something to fall back on, I can see how that's an insurance policy for better or worse.
Yeah. So I would think that the next question that you folks might be interested in is, what is going to be expunged under the MRTA?
Stole the words out of my mouth, Joseph.
Yeah, I've already started getting messages from people wanting to know, exactly. Does this qualify? Does that?
Sure. So we know that back in 2019, when the legislature further decriminalized marijuana in New York State, that for the first time, they embarked upon a quote unquote expungement project. And part of that statute held that all 22105 arrests and prosecutions would be expunged, and all 22110s would be expunged. The problem with a lot of this, unfortunately, especially the 22105s, is that's not a fingerprintable offense. So people would get summonses for 22105. I mean, there are cases where there is an arrest in conjunction with the 22105, usually for something else. It might be that the 22105 is the final charge that someone pleads guilty to, in which case that would be easy to expunge. But if there's no fingerprint taken, it's very hard to figure out how to expunge something. In any event, the other offense that was also made subject to expungement, which is a huge one, especially downstate and probably upstate too, is 22110, which is having marijuana open to public view, or having more than 25 grams of marijuana. That was a B misdemeanor. So all of those are to be expunged as well, both under that 2019 law and under the new law. So, and then the new statute goes on to tell us what else is going to be expunged. Any offense under 22115 of the prior penal law, which means possession of more than 2 ounces, which is an A misdemeanor, that will be expunged. Possession of more than 3 ounces, which is an E felony, that will be expunged. That's under the old law. Under the old law, criminal sale of marijuana in the 5th degree, which is a sale without consideration of less than 2 grams or just 1 cigarette joint, that will be expunged. And then in addition to that, any sale for consideration will be expunged. And you'll see that that sale only goes up to 4 ounces. So if you sell less than 4 ounces in the past and you were convicted of that, that will be expunged.
And Joseph, just for clarification, because with criminal convictions, it's almost rarely straightforward in the process, is the qualification or criteria for these expungements that these convictions have to be only cannabis related?
Well, that's a great question. And the statute actually kind of looks into that a little bit, I think. I mean, I don't know what the debates were that led to this particular configuration of the law, but I can only imagine. So there are going to be, I would bet you that the majority of cases that DCJS and the Office of Court Administration are going to go after first are those that only have marijuana convictions associated with them, because that'll be quick and easy to identify, and they can be expunged without any further consideration. It's going to be more difficult where there might be a conviction of more than one offense within any particular docket, and that happens all the time. Like you could be arrested for, smoking marijuana in public and resisting arrest. If you're unfortunate enough to plead guilty to your resisting arrest, you're not going to be getting that case expunged. Or perhaps, I don't know if the plan is to go in and just expunge one aspect of the case. That doesn't sound very practical or even meaningful, really, because it's going to leave something else out there.
There was a conversation that we had, or that we didn't have. I was a part of a webinar where I was listening in to a number of other leaders were navigating the conversation of social equity, and what they determined is that for cannabis is an entry method not to other drugs, but an entry method into the criminal justice system. And oftentimes, as people get arrested for cannabis, it opens the door for them to get into other types of trouble, whether it's their house getting raided and then finding other drugs or substances, or even something as simple as you mentioned, if it goes to a simple possession and now they also get resisting arrest. Cannabis is oftentimes the precursor for other charges that are added on to a case. And so that kind of tends to complicate it, where it's not black and white of just removing all cannabis or charges that started with cannabis, but more so trying to look at the whole approach holistically.
Okay, so now again, I'm not 100% sure how the legislature intended this to work, and we're going to find out, obviously. But my assumption is that the vast majority of work that's going to be done by the Office of Court Administration and DCJS are going to be on those cases that have standalone, that the only charge that was pleaded guilty to is a cannabis-related charge. And what we know, I mean, we got some information out of DCJS yesterday, which I sent to Penelope. They basically sent a report or a statistical breakout of what they sealed pursuant to the 2019 law. And they sealed, over 200,000 marijuana convictions in a fairly brief period of time. So we know they're capable of doing this. And they break it out by county. And what they're basically saying is that as a result of these sealing efforts or expungement efforts on their part, I mean, it's mandated by the law, people wanted this, right? That 24% of the people who had any expungement are now left without any criminal record whatsoever. So that is a great accomplishment, but it does show, unfortunately, that a lot of the other folks who had criminal convictions for marijuana possession or sale have, kind of to your point, have other convictions as well, which remain. My bet is you're going to find a lot of, this is the next step. I don't know if you guys are focused on this, but 220.03, criminal possession of a small amount of cocaine or heroin or any other controlled substance. Again, just a devastating conviction for people, and really not, worthwhile given what we're talking about. But that's a whole nother topic, okay? This, what this shows is that our government can pick up the ball and at least, get rid of all of those 221.05s, 221.10s, 221.15s, and soon they're going to be doing it to some more serious cases. I mean, this calls for the dismissal, sealing, and expungement of cases that might be considered serious. I don't consider them serious, but people do consider them serious. These felony convictions that happened years and years ago. So that's huge. It leads to the question of, well, what's not getting expunged? And before we actually began, I was saying, this statute maybe could have gone a little bit further, but what's not going to get expunged are the following. The new statute has something called the old statute, 221.30, possession of more than 10 pounds. That's a C felony. That's not getting expunged. That you could understand that, I suppose. And however, that is now kind of redefined. Possession of more than 10 pounds is now a D felony under 222.40. So, somebody who was convicted of the C felony and is now looking at the fact that it's a D felony might have a need to address that. In and of itself, a C felony versus a D felony doesn't really mean that much as far as what the law does to you. What it means, where it means something, is as far as the sentencing is concerned. So if somehow that C felony affected your sentence, whereas a D felony would have been less burdensome. You might have an argument that you should have the C felony vacated and the D felony replaced. That's stuff for lawyers. That doesn't happen automatically. There's a whole another set of rules in the new criminal procedure law, section 440, that deals with cannabis to address that.
And so in that scenario, Joseph, for example, if somebody gets charged with a higher level felony than what they believe they were supposed to be charged, if, like, for example, the police weigh all 10 pounds with the bags and with the equipment, and it adds weight to the scale, and now that ups the charge against them, is there a way to challenge either the arrest, the conviction, or any part of that process?
Well, I'm not sure. If you're asking me, going back to a case that's 10 or 15 or 20 years old, can you challenge that? What you can do is basically make the argument that this is no longer a crime, or it's a crime of a lesser level. That's about it. You're not going to be able to relitigate all of, was I guilty? Was I not guilty? Did you misweigh it? Should it have weighed less? No, I don't, that's not what these statutes deal with. There are statutes that deal with going back to an old criminal conviction and challenging it based on new evidence or evidence that you couldn't discover until recently, stuff like that. But that's not what we're talking about. The other thing that can't be expunged is anything that happened under old 22150, which is sale of more than 4 ounces or sale to a minor. But that was a D felony. Under the new law, at least the part of selling to a minor is only an A misdemeanor, not a D felony. So if you were convicted of that, you have some recourse. And then, there's one other, the most serious cannabis offense in the new Article 222 is sale of more than 16 ounces, or sale of more than, I'm sorry, I'm misspeaking. Yeah, under old 22155, sale of more than 16 ounces, that stays. To me, that I'm not so sure that that's such a significant offense that it should stay, but that stays. You're not getting that sale of a pound of marijuana expunged. However, now, under the law, sale of more than 5 pounds of marijuana is a D felony. So, again, you're looking at a C felony conviction versus a D felony conviction, and there might be some reason to go back and say, I'd rather have my record reflect a D felony than a C felony, and you'll be permitted to do that under this statute. So that's kind of, what the statute provides. The more interesting questions, I think, are going to be, how fast is this all supposed to happen? There is one other interesting provision in the law. It's that, well, so let's say they're working on the expungements and it's taking longer than anyone had hoped. And let's say, oh my God, I know that I have a felony marijuana conviction from back in the day, and I can't wait for this to happen. I can actually go get a fingerprint report taken to show that I have such a conviction that meets these criteria. The way this statute is written, I should be able to go to a court, to a police department, to DCJS, show them proof that I was convicted of something that is no longer a crime. And based on what I'm reading, and I could be reading this incorrectly, but based on what I'm reading, those folks, those actors have to act within 30 days on my request. So, that could be a tremendous floodgate if, crews of people just got their stuff together and said, here, expunge. Whether the court system will actually live up to that requirement remains to be seen. But, I suppose that in the first instance, we have to see how fast these expungements begin and how widespread they are.
Wow.
And now you mentioned that this current initiative doesn't go far enough. If there are updates or proposed amendments to the bill, what are some things that you would like to see to further improve upon it?
Well, this sort of plays into other things that are happening, like Clean Slate, New York. So if I have a prior felony conviction for selling 5 pounds of marijuana 25 years ago, why am I still marked a felon? You know, why do I have to go through each and every day of my life where I'm applying for a job, I'm doing this, I'm doing that. Let's say I served probation or I served time in jail, I paid my fines. And I've now raised my family, I've been employed, I haven't been in any trouble at all. Maybe I got a traffic ticket or something that I didn't pay, but that's it. Why is something, especially cannabis, given how we view it now, why is that something that has to stay with me for my entire life? So to some extent, what I'm saying is broader than just applying it to cannabis arrests. You know, I think back to the 80s and the 90s when so many young people were out on the streets selling drugs and the police were right on top of them, you know, undercover buy and busts, observation, investigation, and just arresting kids inside out. And people got felony conviction after felony conviction and went to jail. And a lot of those people went on to lead, you know, really decent, productive lives, although held back by those convictions. And that, you know, it doesn't go away. So I could talk to the phone with somebody who's my age, 58, 59 years old, and I hear from them, oh, I just went to get a new job, you know, sweeping the floor, and they're telling me no because of my prior felony conviction. I'm like, wow. So prior felony convictions usually. So my thought is, you know, for anything involving marijuana, why not just really wipe the slate clean? You know, sure, that person back in the day made a decision to break the law and buy a substance that's illegal and organize him or herself in that fashion and do such a thing. And yeah, that's incorrect. It's not what we hope for. But, you know, with all of this time passing and with attitudes changing, the law should change too, which it is, which is great. But so should our attitudes about things like a felony conviction for sale. I mean, we all know now, like, what a pound of marijuana is. It seemed like such a big thing maybe back in the day, but, you know, what's a pound of marijuana? You know, 10 people can consume that in a week without much problem if they have the need to do it. So, yeah, I think we need to realign our attitudes about this stuff.
Yeah,
It sounds like we've got a lot more work to do, given that there's been 50 years since the war on drugs started. And we've got a long way to go, but I appreciate the work that you're doing on our end to help reverse the damage that the war on drugs has caused our communities.
Well, that one thing that seems, I don't want to say peculiar, more noteworthy or commendable to me about all of the people who are lobbying for cannabis reform is that most folks in that realm have that feeling about it. They see it as broader than just, oh my God, I want to get stoned, or oh my God, you know, that's not what it is. It's a much broader sense of, hey, you know, we're the people, we're the individuals in this country who live here. And we, you know, we like this substance medically, recreationally, you know, like alcohol, like anything else. And yet for, you know, since, you know, the turn of the 20th century, people have been trying to hold it down and fight against it, a small group of people. And you know, that's wrong. So in a lot of ways, the marijuana space, the cannabis space, it's a real grassroots driven feeling that you know, we can change the law because we're people who actually have this thing in common, that we think that this herb, this ancient herb, is good for people, or, even if it's not good for people, we should be able to choose for ourselves whether or not we want to use it. You know, and the government has just been totally obstructive to the whole process. They won't even test it. They won't even redefine it. I mean, they're talking about making it Schedule 2, which I see someone else just recently wrote a whole post on, saying that that's totally ineffective to the purpose of having it tested and dealt with, so that we could really know what the benefits and the pitfalls of it are. So yeah, it's much more than just you know, one policy issue. It's a big bundle of policies, I think.
Do you have any tips or advice for our community members on how they could start getting more involved in this process and be able to organize and advocate for these issues?
Well, absolutely. I mean, if you as a group are able to, yeah, you might want to survey your membership and see how many people in your membership have these prior convictions. I mean, it's a little bit sensitive, I suppose, but just get a sense of that, especially in your county. And you know, you have your own assembly person, your own state senator. If those cases are not being expunged and dealt with, you know, in a reasonably prompt time, well, then you have something to complain about. And you know, you don't only have to lobby your assemblyman and your state senator, you can also lobby DCJS. They're actually, I learned yesterday, they're pretty reactive. I called them, I called their press office, and I just identified myself as a citizen, and the press office called me back, which I was actually surprised by. And within the space, and I told the press office what I was looking for, and within the space of the day, they sent me a nice little email telling me what the 2019 law was, you know, and giving me these statistics. So I have a feeling that they're kind of getting ready for this. They're probably bracing for it because they know it's going to be a lot of work, and you know, people are going to be impatient to see it get done. And if they don't do it right, they're going to be subject to criticism. So I would imagine it's gonna start happening, but you guys can certainly make it happen even faster.
Wow. Thank you. I didn't even realize that was an area that we could really get involved in. I mean, to be perfectly honest.
Well, you know, I mean, and it plays into the business sphere that you're dealing in as well. And this is, you know, for me, it also does. I don't, you know, the way the new legislation is crafted is licenses are going to go out to people, many of whom it's irrelevant in a lot of ways whether you had a prior marijuana conviction, you know, under 221 or 220 or any of that, because of the way the licensing is focused. However, I would presume that most folks who are going to be involved in the distribution and the growth and the processing, et cetera, if they do have a prior conviction, they're going to want that wiped off. I mean, because now they're the people actually in the process of creating, you know, this product and the culture around the product. So, you know, that's another, I guess, reason why this should happen quickly, so that, you know, this group that is going to be involved, this business group that's going to be involved in this, aren't a bunch of folks who have to think, oh my God, I have a prior conviction, I have a prior conviction. No, your government has said, forget about that. You don't have to worry about that anymore. It's done, it's clean. There's no embarrassment to that, you know. So I'm not sure I'm conveying that clearly enough, but there's a feeling of pride almost that says, hey, I'm in this area now, I'm in this business, and I don't have any prior convictions for any of that stuff, because finally, the governor, Mario Cuomo, says it's okay.
Yeah, I mean, because it used to bar, you know, our legacy market from going into the legal side, because we had all these laws saying, you know, oh, if you've had the felony, you can't be a part of the cannabis industry. And those are the exact communities and people that we want to bring over into the legal market. So yeah, I'm very proud that our legislation has that written in there so that people can play a part and move their, you know, we've got the businesses running in New York State. You know, we've got a huge cannabis industry already, and we just want to slide a lot of these people, our experts really, you know, from that legacy side into that, you know, legal retail sales, and something they can be very proud of, you know.
Absolutely.
So can you briefly tell us, I'm sorry.
No, go ahead.
Before we leave, I don't think we've actually said what our possession laws are now. And just in case anybody's listening and they'd like to know, what can you be on the street with, or, you know, on your person?
Yeah, I have to be honest with you. I didn't prep myself for that, although my recollection is that on the street, you can be in possession of up to 3 ounces. In your home, I'm thinking it's up to 6 pounds, and I'm not, don't quote me on that. Penelope, you straightened me out on the home growth issues. So eventually you'll be able to grow up to 6 plants, or it seems 6 mature and 6 immature.
It's actually 3 and 3. Yeah, it's 3 immature, 3. Well, if you per adult, so if you have 2 adults,
that's what I mean, but a maximum per house of 6. So 6 and 6.
It can get confusing to people. So
right, that you have to wait for a long time if you're non-medical to do 18 months after regulations are put in place. So those are the main statutes, and then the sale, obviously. The most significant offense, I believe, is the sale of, I think, like 100 pounds, which is a C felony. And you know, one thing that is good, which has always been good about the marijuana laws in our state, is they don't carry mandatory jail sentences. So, you know, and most, you know, in Penelope's neck of the woods, this might not be true, but down here, no judges are giving jail sentences on felony marijuana cases, even felony sale cases. So that's another offense, the C felony. And then there's a D felony sale case, which I believe is for more than 4 ounces, which I think is incorrect. I think that's too low a level to you know, to make a felony out of. But again, I don't have those directly in front of me. If you guys wanted to do another thing with just that focus, I'd be happy to. But that's pretty quick and easy.
You gave us a lot to think about, opened up our eyes to the world of expungement and how that's affecting the people of New York. Where can they learn more about the topic? Where can they learn more about you? And where can they learn more about the work that you're doing?
Well, people can learn a lot about all of this by logging onto LinkedIn, and Penelope, I think, knows the names of the groups better than I do, but joining the different LinkedIn groups so that you can actually see what everybody out there is doing, both in the social equity, in the business, in the growth, in the science, the medical. I mean, there's so much, there's a wealth of information that's being dumped on there. I mean, joining your group obviously is a tremendous idea, which I've recently done. You know, as Penelope knows, she has search terms with Google that drives all the latest news to her. In New York, there's a little New York City, there's something called The City, which kind of keeps people updated on local issues, and it often touches on the cannabis issues. I'm not sure where else to be looking. I mean, you know, if you want to learn about me, you're welcome to call me or visit me. But you know, my information, if it's not on your website yet, will be. Bernfeld, DeMatteo and Bernfeld in Tarrytown, New York. So.
Fantastic. Joseph, thank you so much for taking the time to meet with us today, educate us on these very important issues, and for the work that you're doing on behalf of the community. We truly appreciate it, and we look forward to having you back again on our show.
Thanks to both of you. I really enjoyed sitting here and talking to you. You guys are great.
Oh,
wonderful. And to our members, thank you so much for watching and tuning in with us. Don't forget to follow us on Facebook, visit our website, join the communities, and be a part of the conversation. Until then, we'll see you on the next episode of the Cannabis Community Insider. Have a good rest of your day.